Welcome to this edition of Practical Probate. I'm Dom Calabrese. Since 1995, I've been a Connecticut attorney, and since 2003, I've been a Connecticut probate judge. Today, I'm going to talk about living trusts, myth versus reality. The purpose of this presentation is to give you some information. It's not intended to be legal advice, and you should not rely upon it as legal advice. For legal advice, you need to consult a qualified attorney. So what I'm going to cover in this presentation on living trusts is what living trusts are, myths and realities. There's a lot of myths about living trusts, and I intend to dispel those myths in this presentation. The utility of living trusts. Any estate planning tool, living trusts are one estate planning tool, have advantages and have disadvantages. And I'm going to talk about both in this presentation. I'm also going to talk about alternatives to living trusts and give you a few examples of how living trusts might operate and how they fit into a comprehensive estate plan. So what are living trusts? Well, trusts are simply a contract between the trustee and the grantor, the person who creates the trust. And a lot of times in living trusts, the trustee and the grantor are the same people. There's a lot of different kinds of trusts for different purposes. There's legal seminars that attorneys go to all the time that last for days, even a week, that are devoted to trust. So obviously in this very short presentation, I'm just going to highlight a few areas of trust, but it's certainly a very significant, very large, and very complex area. A living trust is simply a trust that's set up once when someone is alive. Attorneys talk about them as inter vivos trust, meaning in life or within your life. But any trust that's created while somebody is alive is a living trust. The alternative type of trust is called the testamentary trust, and that's a trust that's set up in somebody's will and doesn't come into existence until after that person passes away. Now, among living trusts, there's revocable living trusts and there's irrevocable living trust. So a revocable living trust is the most common type of living trust, and it's simply the kind of trust that you can create for yourself. You can put assets into it, you could take assets out of it, there's no tax consequences to it, it's very easy to move assets into and out of a revocable living trust. An irrevocable living trust, and I'm not going to really spend a lot of time talking about irrevocable living trusts today, are different from revocable trusts because generally they can't be revoked, and once you transfer assets into an irrevocable trust, it's difficult, if not impossible, to get them out of that trust. So that's really not the kind of trust I'm going to talk about today. So the myths in this presentation are taken from an actual living trust seminar that takes place in Western Connecticut on a regular basis, probably 3 or 4 times a year. There's a big law firm that comes through different parts of the state of Connecticut, and they give these living trust seminars at hotel ballrooms. And the myths in this presentation were taken from one such seminar that I attended several years ago. So one of the myths is without a living trust, most people can lose 50% or more of their estate to taxes and probate fees. And the reality is, for the vast majority of estates, in 2019 when I make this video, estates with a value of $3.6 million or less, the amount that can be lost to estate taxes and fees is far, far less than 50%. In Connecticut, probate fees average about 1/3 of 1%. Now, in the presentation I went to that I based my presentation on today, they talked about California probate fees. Well, if you're in Connecticut, Connecticut probate fees really should be what you're concerned about, and they average about 1/3 of 1%. So by way of example, a gross estate in Connecticut that has a value of $600,000 is going to have a Connecticut probate fee of about $2,100. Attorney's fees usually run between 1 and 5% of the gross estate. The vast majority of those run between 1 and 3%. So I'm not sure where they get their 50% number from. Certainly if you incur federal estate tax, that's 40%. That's substantial. But in 2019, the lifetime exclusion for federal estate taxes is $11.4 million and $22.8 million for married couples. So we're only talking about very, very large estates, really a fraction of a percentage of the total number of estates that are opened in the United States every year could incur anywhere near the 50% number that was quoted in the seminar that I attended. Another myth is, unlike wills, a living trust can ensure that your wishes are carried out and not subject to legal challenge. Well, the reality is a trust can be challenged in court just like a will can be challenged in court. One of the differences, though, is once a will is admitted to the probate court, a potential opponent of that will only has 30 days to appeal the probate court's decision. Once that 30-day period expires, that will is admitted to the court, and it's highly, highly unlikely that the will would be thrown out at that point. There's no similar provisions for trust. There's no time limit to challenge a trust. Another myth is that you can place all of your assets in a living trust. Now, I will tell you the vast majority of assets could be placed into a living trust. Bank accounts, real estate, motor vehicles, tangible personal property like jewelry and artwork, all of those things can be put into a living trust. But some things can't be put into a living trust. And one example of those are stock options. Another myth is that a living trust will help your family avoid probate fees. Well, in Connecticut at least, assets in a living trust are includable for calculation of probate fee liability. So from a tax standpoint, assets in a revocable living trust, are treated as if they are your assets when you pass away. So they are not going to reduce probate fees for sure, at least not in Connecticut. Other states, the situation may be different. Another myth is that a living trust will help your heirs avoid probate. Well, the reality is there's two purposes to probate in Connecticut. One purpose is to determine the legal owner of assets owned by the person who passed away. And a living trust certainly can avoid that part of the probate process in Connecticut. The other reason why we have probate proceedings when people pass away in Connecticut is to ensure payment of Connecticut probate fees and Connecticut estate tax. And a revocable living trust has no effect on reducing either of those things. So a probate fee is not going to be reduced by the assets in a living trust. Certainly, tax planning can be used in a trust to reduce or minimize estate tax liability, and that's really, in Connecticut, the only way that someone can reduce estate tax liability while still retaining control over their assets while they're alive. But it will not reduce probate fees. Another myth that I heard was that a living trust can save money for anyone who has assets worth $75,000 or more. I'm not really sure where they came up with that number. In any case, I don't believe that the asset level of any person is a good reason all by itself to decide whether they should have a living trust or not. I think it's far better to sit down with an attorney who's going to take the time to explain living trusts to you, to help understand what your objectives are, what your situation is, and then help you decide if a living trust has value for you or not. It should have nothing to do with avoiding probate, or it shouldn't have anything to do with the level of assets you own. Perhaps somebody with a lower level of assets than $75,000 would find utility in a living trust, and conversely, someone with a larger value of assets may decide that a living trust is not worth the cost to them. So what can living trusts be used for? Well, one of the advantages, and I touched upon it a few minutes ago, is if you have assets in a living trust, when you pass away, those assets pass to whoever or whatever you name as the beneficiary in the trust outside of the probate court. So the probate court is not involved in the transfer of assets, and the transfer of assets in that trust under those circumstances are automatic. There's no delay because you have to go to the probate court. Another very important utility or advantage of living trusts is they will allow for the management of the assets in that trust should you become incapacitated. Incapacity is far more common than most people believe. I spend more time in my probate court hearing room on conservatorships than I do on everything else put together. And most of the folks who are subject to conservatorships could have easily avoided them with some estate planning that might have included a trust. It also avoids probate administration and the public's ability to see what your family business is, because a trust generally is not going to be recorded anywhere. It's a private document, and unlike a will or anything else that's admitted to the probate court, with just a couple of notable exceptions, a trust will not be subject to public inspection by people who maybe you don't want them to know what your family business or what your personal business is, what you own, who you owe money to, and where your money's going to go. Trust can also be used for asset protection. We have a new trust code that's going to come into effect in Connecticut on January 1st, 2020. That new trust code will allow for domestic asset protection trusts, but certainly even under the current law, there's some element of asset protection that may be realized with a living trust. Some disadvantages of living trusts are that they're only effective for assets that are transferred into that trust while you're alive. And I've seen many situations where someone passes away, their family member comes to the probate court, the person who passed away had a living trust, but they never transferred any assets into it. And while I'm not saying at that point the living trust is useless, a lot of the advantages of living trust that I just talked about won't be realized because no assets were transferred into it while the person who created that trust was alive. There's certainly an expense in creating and funding the trust. It doesn't reduce probate fees, and it is subject to challenge in court. Some people may see the lack of probate oversight as a disadvantage as well, and certainly less expensive alternatives may accomplish the same thing. So what are some alternatives to living trust? Well, having property in survivorship is an alternative. Real estate, personal property could be in survivorship. And that would mean that when one of the owners of that asset passes away, the remaining owner or owners, when it's in survivorship, will automatically get that asset. However, the disadvantages of survivorship property are many. Loss of the control of assets, liability issues, potential gift tax issues. With real estate, such a transfer may trigger the due on sale clause in the mortgage, which is in every mortgage. And you still have to get estate tax clearance, at least in the state of Connecticut, for survivorship real property. A will is good for solely owned assets when you pass away. The advantages are it ensures that your assets that are solely owned when you pass away are transferred according to your wishes. Wills are very easy to change. They don't require a change in asset ownership. They're generally inexpensive, and challenges to a will are very limited. The disadvantages of a will are that there is the probate process, which in Connecticut can last 8 to 12 months. There's an expense associated with probate court administration. They can be contested with limitations that I talked about. And once they're admitted to probate, they become subject to public disclosure. Disadvantages are certain events revoke a will automatically, like divorce, like marriage, like the birth of a child who's not specifically provided for in the will. And certainly a will has no use at all in managing your assets while you're alive. A will only has utility after you pass away and it's admitted to the probate court. You can also do lifetime gifts. That way you get to see the objects of your bounty enjoy the gift, and you know for sure that they're going to get the gift. So those are two advantages of lifetime gifts. It could reduce probate fees if they're made more than 3 years from the date of death. and it may completely preclude the need to have any probate proceedings if you manage your estate properly, including the use of lifetime gifts. The disadvantages of a gift are loss of control over the asset, potential gift tax issues, and a period of ineligibility for Medicaid or Title XIX benefits. I'm running out of time, but there's a couple of other tools that I'll talk about in other presentations, like a durable power of attorney, which can be used to manage your assets should you become incapacitated, healthcare documents that would include a healthcare representative, the appointment of a healthcare representative, an advanced designation of conservator, and an advanced directive, also known as a living will. Thank you.